We've allocated 20 minutes per side for argument. I understand that the state and counsel for Ms. Adelson have agreed to share that time, depending on the questions asked from the court. With that, if counsel is ready, you may proceed.
Good morning, Your Honours. May it please the Court. Kirsten Kawas on behalf of the petitioner, Katherine Magbanua. If Your Honours would permit, I am requesting to reserve 5 minutes for rebuttal. We are present before this Honourable Court this morning to address Ms. Magbanua's pre-trial discovery rights under Florida law. Rights that are significant to any party in litigation, but even more compelling to a defendant in a criminal case. As this Honourable Court has noted, the entire purpose of pre-trial discovery in criminal cases is to assure a defendant charged with a crime the right to a fair trial. In the proceedings below, the trial court has stripped Ms. Magbanua of her discovery rights under Florida Rule of Criminal Procedure 3.220 by summarily granting a protective order barring Ms. Magbanua from taking the deposition of a Category A material witness, where the only basis presented to the trial court was the blanket and preemptive assertion of a Fifth Amendment privilege against self-incrimination.
If I could interrupt, you said summarily denied, so that's without a hearing?
It was denied, yes, Your Honor.
It's just on the papers that were filed?
It was just the motion that was filed. Ms. Magbanua responded, and the trial court issued an order without a hearing.
Okay, thank you.
Ms. Magbanua readily acknowledges that the writ of certiorari is an extraordinary remedy, one that can only be granted if it is established that the trial court departed from the essential requirements of law, resulting in material injury that cannot be remedied on appeal. It's our position that all three elements have been more than satisfied by the circumstances in this case. In regard to the material injury, the trial court's order forecloses any opportunity to take the deposition of Wendy Adelson, the ex-wife of the decedent, Dan Markell.
I have a few questions on the irreparable harm. First, beginning with Judge Hankinson's order.
Yes.
You also asked that he exclude the testimony at trial that would be offered, but he has left open the door that that could be reasserted at trial. How does that inform the irreparable harm prong?
Well, that also stems from the irreparable harm that implied from the order that he issued on the motion to exclude, that said that it was denied without prejudice to reassert at trial. One of the issues concerning irreparable harm that Ms. Magbanua is having is the fact that that Ms. Adelson is being allowed to testify at trial without having the opportunity to depose her prior to doing so.
Okay, and my understanding is that Ms. Adelson has asserted her Fifth Amendment privilege to answer any substantive questions on grounds that those questions and answers may tend to incriminate her, correct?
Right, any and all questions.
And also that she has also asserted that she may be offered immunity by virtue of the self-executing statutory provision, correct?
Right, under a state subpoena.
But the state has not yet subpoenaed her.
The state has not yet done
And she
so.
hasn't testified.
No.
Right, so there's no immunity at issue at this point.
No, and I believe that the respondent made it clear in their response that they would not be seeking to take her statement prior to trial or issuing a subpoena to her until it's time for her to testify.
And the state has further asserted that it is not going to offer blanket immunity to Ms. Adelson, correct? In its response?
I believe that they had said that they would offer immunity to the testimony that they plan. Well, it would be immunity for both the direct and cross. Under the case law, the cross would be covered as well by the immunity, but that she will be given immunity to the questions that she's asked during trial. As conceded by the respondent in their response, Ms. Adelson is the witness who will be called at trial to establish a theory of prosecution that Ms. Adelson's family members, particularly her mother and her brother, contracted the perpetrators to effectuate the killing of her ex-husband.
Let me, if I could interrupt, I'm sorry to break your flow. Let's say that no deposition occurs or that the Fifth Amendment right is asserted. So you go to trial and Ms. Adelson testifies.
Right.
And let's say she testifies to certain facts.
Right.
But it turns out that those facts really aren't critical to your client's case in the sense of Adelson being present at the crime and things like that. Okay, so they're sort of tangential. Even if the information isn't disclosed before trial, you don't know what she's going to testify to, but then she testifies at trial, it still could be harmless error in the sense that it wasn't given to you beforehand, correct? In other
Could
words,
you repeat the last part, Your Honor?
I mean,
I'm
there's
so sorry.
certain, if the state holds back on discovery,
Right.
failed to give you discovery that you arguably should have had, but it turns out that it really wasn't prejudicial in the end. Couldn't that be the case? Couldn't that be an outcome here?
It very well could be the outcome. The problem that we're having here is because we actually do not know what her testimony is going to be. So there is the possibility that information that Ms. Adelson does have may very well be relevant to the defense in this case. And that's the problem. If the proper procedures had been in place by the trial court, which goes to the essential requirements of law.
I mean, all you have at this point, I'm sorry to interrupt,
Oh, no
is what the state says is that the import of her testimony, this is from their papers
From their
filed in
response.
this court, the import of her testimony, Adelson's, appears to be to provide the background and motivation for the murder. She does not appear to be the linchpin connecting petitioner to the crime. That's sort of the extent of what you know about what she may testify to at this point.
Right, and I can make the assumption that that is based on the statement that she gave to the police on the day of the murder in 2014. She was recently subpoenaed in 2019. 5 years has passed since the passing of her ex-husband. There's so many things that could have happened in between that time. There's so much information that she could have potentially have gotten, conversations that she's had with her family members, that it's just in a state of uncertainty right now.
And even if Ms. Adelson testifies at trial under a state subpoena, the defendant would still be limited by the scope of the direct examination.
Exactly, Your Honor. Ms. Adelson is without a doubt, returning to the material injury, Ms. Adelson is without a doubt the definition of a material witness in a criminal case. And defense counsel is entitled to any non-privileged information that she may have that's relevant to the case. Not only to properly prepare for Ms. Magbanua's defense in anticipation of the trial, but also to potentially uncover different evidence, different witnesses, whether or not it's favorable to the defense or not.
Could you distinguish two of our cases, first Yutse versus State and our recent decision in Segura regarding irreparable harm? There we said that the burden of enduring a second trial is not the type of irreparable harm that can be remedied on certiorari.
Absolutely, which is why that was not an argument that was made by us in the petition. I believe that you'd say it's distinguishable because in that case, the defendant in that case had alleged that the prosecution had failed to supply outstanding discovery items, even though the time had long passed since they had filed the writ at that point. And the defendant in that case alleged that the discovery violations are not allowing him to make progress on his defense. And this honorable court held that the harm done by failing to provide information is something that can be remedied on appeal. And that deals with the state's delay in providing discovery. This case deals with the court foreclosing deposition of a witness and not providing late discovery if the trial attorney in that case properly preserves the issue by moving for a Richardson hearing and having the court rule on the Richardson hearing. A ruling on a Richardson hearing is reviewable on direct appeal. And also in Yutse, I would note that in footnote 1 of this court's opinion, this court recognized that it found irreparable harm on very isolated occasions. And this court cited to two cases, the Quella case and the Baldwin case. And in Quella, there was a granting of a protective order that caused irreparable harm because petitioners would be denied discovery, and the denial is just, it's not reviewable on direct appeal because they can't determine how the denial of the discovery would have affected the outcome of the proceedings.
Can you cite a criminal case where a petition for writ of certiorari has been granted in a discovery dispute under Rule 3.220?
Absolutely not, Your Honor. If I could have, I had scoured looking for a criminal case that deals with not just the denial of discovery under 3.220, but this specific issue where a defense counsel is being barred from taking the deposition of a material witness. And it's unprecedented in the criminal context.
Does it matter? Does it matter whether whether this is a civil context in the larger sense? Does that versus the criminal, does that determine the immunity and other issues?
I mean, I actually believe that in terms of a criminal context, it would probably be more egregious just because of the importance that's attached to criminal discovery rights. It's different in civil because there isn't the issue of the immunity And a lot of times in the civil cases, it deals with parties to the proceeding. Criminal cases are very different in that aspect. The only party to the proceeding is the state of Florida. There's no such thing as where civil would classify someone as a material witness. Every witness that's listed by the state can be considered material because the state's literally the only party to the proceeding and the defendant. And I think that's how it would differentiate between a criminal context and a civil context.
If you could, tell me, if the trial court's order here were quashed and you were allowed to take a deposition, so now we're in the deposition, Ms. Adelson sits down and is sworn in, you start asking questions, what's your name? She answers her name. I assume she'll answer what her name is. I mean, at some point, there are going to be some questions, I presume. She's going to say, I take the fifth.
Yes.
There's one category of questions where she'll answer, and other categories she won't.
Right.
Right now, she says she's not going to answer any questions. Any
Right.
substantive, I guess, was the question, but that always begs the question of what's substantive. I guess what I'm getting to here is, how would this play out if the order was quashed and you took a deposition and Ms. Adelson took the Fifth Amendment on innumerable questions? How does that benefit your client?
Which is how it would play out is how I argued that it should have played out in the trial court. She should appear at the deposition and per Florida law and assert her privilege on a question-by-question basis, which I'm assuming we are not arguing that Ms. Adelson doesn't have a Fifth Amendment privilege. There may very well be questions that are asked in the deposition that may warrant coverage from the privilege. But she needs to do it on a question-by-question basis. Then it is up to the trial court to determine whether the privilege was properly applied to that question. It is not up to the witness to determine whether a question or an answer is protected by the Fifth Amendment.
So how would that play out? Would there be a deposition, there would be objections, there would be asserting of rights, and then the trial judge would have to review the transcript to determine?
I believe that Ms. Adelson would appear for the deposition. She would assert her privilege on a question-by-question basis, whether it's all or whether it's some. We would certify those questions and then take it before the judge and have the judge determine at that point, which is a proper procedure, whether the questions that were asked by defense counsel are questions that are entitled to the privilege, to the protection from the Fifth Amendment
Well,
privilege.
to follow up on that, the state's answer to the demand for discovery lists a number of pieces of evidence that Ms. Adelson had in her possession, including an iPad, lists of students, credit card records, and bank records. Are those the types of questions that you may ask regarding the authentication of evidence, and would she be able to assert the privilege with regard to those?
I believe it would be a lot easier if I was the trial counsel in this case, but I do believe that if that evidence has been provided, that those are questions that would be asked by defense counsel during the deposition. And like I've reiterated, Your Honours, I'm not saying that she's not entitled to the privilege. It's just not up to her to decide whether the privilege applies to certain questions. This court has held that there's no legal authority for a blanket, anticipatory Fifth Amendment protection. The proper procedure should have been followed in this case, which was to have her attend the deposition. She can assert to questions that she truly believes will lead to criminal prosecution, and at that point it would be up to the lower court to determine whether the Fifth Amendment was properly applied or not.
But you don't dispute that the trial court had discretion to issue a protective order under Rule 3.220 for purposes of harassment, delay, et cetera?
Absolutely no. The rule is very clear that, and that's actually where I think it differs a little bit from civil, because I believe it says in the criminal rule allowing for protective orders, shall, but it has to be done on good cause. And it's Ms. Magbanua's position that a blanket assertion of a Fifth Amendment privilege without going through the proper procedures doesn't supply good cause for the issuance of a protective order, especially when Ms. Magbanua has the right under the rules of discovery to conduct her deposition.
Here's what I'm thinking. You've got three categories of information called A, B, and C.
Okay.
A are questions that she'll answer because there's no Fifth Amendment issue. Straightforward questions. That's category A. Then there's going to be category C, which are areas where substantive questions where she will assert the Fifth Amendment privilege and not answer. And then she's entitled to that.
Right.
That's okay. There's this third category, B in between, where she takes, or she exercises her Fifth Amendment privilege and not to testify, goes to the judge, and the judge says, no, those questions have to come in. I'm trying to see, does that help how does that help you in the process? In my mind, it seems maybe perhaps helps you to segment what what factual questions are important and what ones aren't, and that maybe helps your defense in some way. Is that where you're coming? I'm trying to pin it down, what it is you're
Yes, Your
trying to
Honor,
get out of
because
the deposition.
the problem that we're having right now is we have absolutely no idea what she's going to say. She may very well not have information. She may very well have information. But she can't just avoid a deposition by blanketly asserting her fifth. I actually have no idea what would come out during her deposition. I have no idea whether she has any information that would be relevant to the defense. Based on the state's theory of prosecution, we can only imagine that she would have evidence or would have testimony that she would give in the deposition that would at least cause the defense to go down different avenues of investigation or at least effectively prepare for her cross-examination at a minimum.
Counsel, would you say that the protection afforded under the 914-04, the use and derivative use immunity, is that any better for her than asserting the Fifth Amendment at deposition? Is she equally protected by asserting the Fifth at a deposition?
She's absolutely protected at trial under a state subpoena. Even I believe that there is case law that says even her cross-examination testimony will be protected.
But at trial, certainly under
Right,
state
at trial.
subpoena, but at the defense deposition, she's not within the scope of the statute. Is she any less protected because she's relegated to asserting her Fifth Amendment privilege at the deposition?
I don't believe that she would be any less protected because if she is properly asserting her Fifth Amendment privilege, the lower court will make that determination. And those answers to those particular questions won't come into trial because she can't get on the stand and plead the Fifth. At least the defense would have some direction at that point in terms of her cross-examination to gauge which areas to go into and which not. It's just as it stands right now, the defense has absolutely no idea what Ms. Adelson is going to say if she takes the stand without submitting to a deposition.
If I could ask quickly, as we sit here today, there's been no disclosure of any contractual immunity agreement. In other words, there's been no verbal promise or no written promise about immunizing her testimony by the state.
Not to my
And
knowledge, Your
if there
Honor.
were, that you would have a right to know that, and you would have been provided that by now.
Exactly, Your
Okay.
Honor. And I believe that potentially if the state, which they've made it clear in their response that they're not going to do, I'm actually not even sure whether if they issued the subpoena now for trial and we were to depose her, if that would be covered by immunity. That's not an issue that I researched because of the fact that the state had made it very abundantly clear that they will not issue the subpoena unless it's simply for her to come in and testify at trial. Absent the procedures that are mandated by Florida law, there was no good cause to grant the protective order in this case. So the trial court's conclusory and predetermined findings that Ms. Adelson had a legal basis to assert her Fifth Amendment privilege and that the deposition would serve no useful purpose departed from the essential requirements of law in Florida. And as Your Honours noted, there is no criminal, and this was a fact that Ms. Adelson and the respondent relied on heavily, that there are no criminal cases on point for this issue, and that's just simply because it's unprecedented. There's no criminal case where a witness has attempted to avoid a deposition by making a blanket assertion of the Fifth Amendment privilege and succeeded, yet then still be allowed to testify at trial. And to let the trial court's order in this case stand is going to set a harrowing precedent that any witness in any case can do just that and make a blanket assertion of Fifth Amendment and will be foreclosed from submitting to an opposing party's deposition. And because the trial court's order allows for the very type of the miscarriage of justice that certiorari was set out to prevent, Ms. Magbanua respectfully requests that this honourable court issue a writ of certiorari quashing the order below. Thank you, Your Honours.
May it please the court, Tricia Max Pate representing the state of Florida. And the state of Florida is in kind of a unique position in this case that we're much more concerned that this is timely resolved so it doesn't further delay the trial rather than the actual outcome of the petition, because it doesn't affect us one way or the other to the extent. But I would like to clear up something. One of the questions seemed to apply there might be a discovery violation here. And Ms. Adelson was disclosed in discovery, and her statement that she gave to law enforcement has been disclosed in the CD of that interview, has been provided. So there's no discovery violation by the state. The state is just not offering her contractual immunity, and the state is not calling her for an investigative procedure or a deposition. We're not issuing a subpoena, so she doesn't get the immunity provided under the statute. So that's,
I didn't hear anything about a discovery violation. What are you referring to?
I thought one of your questions was asked if there was a discovery violation.
No,
that would
my
be
question was if there were contractual immunity as we sit here today, either verbally or in writing, that would have to have been disclosed at this point, correct?
And that is not going to occur. So the state
If
is
it hasn't
not,
occurred, it's not going to occur, you're saying?
it's not going to occur. The state is not offering her a contractual immunity deal. She will get immunity. The state is going to subpoena her for trial, and she will get immunity for any testimony provided at trial.
And counsel, you stated in your response that the state was not going to offer blanket immunity with regard to her trial testimony. How is that distinct from the use immunity and transactional immunity under the statute?
I think what I meant by blanket immunity is like a contractual immunity, that she has this immunity, and she, I think one of the co-defendants got an immunity agreement with the state where they were providing testimony in exchange for their plea. Or a plea deal or something like that. We're not offering like a blanket, and she's our witness and providing investigative information or that type of thing. She will get use immunity for her testimony at trial, whatever is derived from her trial testimony. But again, the state is intending, and I talked with the prosecutor, I'm not on the prosecution team, but I mean, the purpose of calling her is to establish the divorce proceedings, the custody proceedings that provide the motivation for the murder, to identify telephone numbers and stuff. It's, I don't think the state has any information directly tying her to the petitioner, other than they know each other, I think, through her brother.
Wouldn't the questions the state asks might differ some from the questions the defendant might ask?
It's
I mean,
possible.
what's important to the state is important to the state, but what's important to the defense is important to the defense. So why does the state just get to ask the questions?
Well, the state doesn't just get to ask the questions. They can ask questions on cross-examination.
Limited to what you've asked.
Correct. I mean, they can subpoena her. They just can't offer her immunity, but she has a Fifth Amendment privilege to assert her rights.
But they can't go beyond what you questioned her about at trial.
That's correct.
So to be clear, to the extent that the state doesn't ask questions about the purported co-conspirators in the Adelson family, and Ms. Adelson doesn't respond to those questions, she would have no immunity from future prosecution.
Correct. That's correct. So we've filed a response. I think cert is a very high standard. I think it's very high. They haven't supplied any criminal cases, but again, our interest is far more important that it's resolved. If the court was considering granting the petition, we would ask that you do it rather quickly. So if we have to then litigate what is Fifth Amendment privileged or not, we will have plenty of time to do so. Now, the immediate trial has been continued, and I don't think they've set a new trial date, but the state attorney's office was very concerned because this case has been pending for a long time and continued several times, so that it would be resolved in plenty enough time. So whatever the new trial date is set, that it would not delay that. So, and other than that, I will defer to my co-counsel.
Can I ask you one question?
Yes.
And in fairness, I'll ask you the same question I asked the petitioner, which is the Fifth Amendment privilege at deposition not subject to 914? Is that protection any different in quality than the 914 protection? Is she protected adequately if she can, question by question, assert the Fifth Amendment privilege at her deposition, in your view?
She can assert that, in my view.
And is there any qualitative difference between the protection she gets from that and the protection she automatically gets under 914-04?
I don't think so, as long as I guess.
I mean, if she doesn't testify, then she doesn't need the immunity because she hasn't said
Right.
anything, so.
Right,
okay.
if she, yes. I
Okay.
think, so, I mean, if the state subpoenas her, she can answer freely because she has immunity.
Right.
If she's at a deposition and she doesn't assert her privilege, then whatever she was to answer would be used against her.
And she's in control of whether she asserts the privilege as
Right.
to a specific question.
So I think that
or
would be
not.
the main difference.
Okay.
Well, I'm sorry to take more of your time. Has the state ever used 914, the provision 914, to have a pretrial deposition of a state witness? To your knowledge? In other words,
I would think so. I think they have probably called people in. I would think so.
Well, the reason I ask is, what's the harm of having a pretrial deposition where the state subpoenas the witness, the questions are asked and so forth, and then
Because if we subpoena someone for an investigatory deposition, if we subpoena them, they have immunity.
but you're going to get it at trial as well.
But we're controlling the questions we're asking at trial. And so we have much greater control over that. But it could open the door to immunity far greater if we subpoena for a deposition and she says, oh, yes, I confess I was, not that the state suspects that she's going to say that, but, if someone did, then they would have immunity. So what the state is going to do is just call her at trial and use her pretrial statement there. But the courts cannot force the state to depose.
Well, I think we got that message, yeah.
Yes, so that was our greatest concern. You can't force us to offer immunity.
And I'm not, by raising the question, I was saying that the court would force you. I would say, why doesn't the state consider it in some cases?
I'm sure they have, and I'm sure prosecutors weigh that question and decide what to do in a case-by-case basis. I'm not in the trial courts, so I'm not as familiar as how many times they might do that.
I'm pardon to interrupt, but if the state does a deposition, subpoenas the witness, and the state can limit it to certain questions, and that'll be it. Just because you've set a deposition doesn't entitle the defendant to go off in other areas, or am I wrong on that?
I would have to research that because we usually don't litigate depositions. I'm not sure if it's exactly like cross, or direct and cross where you're limited to the scope of cross, and then a judge wouldn't be there. I'm sure they could object.
It would seem like the state would be in control and would ask the questions that they want to extend immunity for, and they wouldn't want it to go beyond that.
Correct.
Okay.
My understanding, though, is the state has absolutely no intention of subpoenaing her for a deposition. So I'll defer to good counsel.
Thank you,
after this.
counsel.
Good morning, and may it please the court. My name is Michael Califano on behalf of non-party Wendy Adelson. This court lacks jurisdiction to grant Ms. Magbanua's petition. To establish certiorari jurisdiction, the court must consider whether the challenged order results in a material injury for the remainder of trial and whether it cannot be cured on post-judgment appeal. The petition fails under both prongs. Now, the state indicated that it doesn't believe that this motion really impacts it. And respectfully, I would disagree. I think that this motion not only impacts the state and its cases going forward, it impacts this court. What the petitioner is asking this court to do is open the floodgates to piecemeal interlocutory appeals by criminal defendants when time and time again this court has held that a criminal defendant is not entitled to certiorari relief because it could appeal these issues via post-judgment appeal. The petition is inviting this court to go down the slippery slope of allowing a criminal defendant to raise arguments on an interlocutory appeal rather than the normal appeal process, which is to raise the very same arguments that Ms. Magbanua is raising today in post-judgment appeal.
Well, wouldn't the trial judges grant a blanket immunity for any question asked, including what's your name? Why isn't that sort of a departure from the essential requirements of law? Why wouldn't that be a...
Here, the judge didn't grant blanket immunity. The judge granted a protective order to prevent...
I'm sorry, I said immunity. I meant protective order.
Yes, granted a protective order to protect Ms. Adelson from attending a deposition that would serve no useful purpose because counsel represented that Ms. Adelson would assert her constitutional rights to any substantive questions.
I mean, what does that mean, any substantive question? I mean, this is a Category A material witness who is at the very heart of this prosecution. She is the ex-wife of the victim, and her parents are uncharged co-conspirators at this point. So how can it be that any substantive questions, including questions regarding the evidence in her possession, should be protected under the Fifth Amendment?
Well, Your Honor, the Fifth Amendment is, one of its basic functions is to protect the innocent, and to protect the innocent who may otherwise be ensnared by ambiguous circumstances. Your Honor had asked whether Ms. Adelson would have the same protections in a defense deposition that she would have in a state-compelled testimony at trial under statute section 914.04. And the answer is no, because at a defense deposition, there's a risk that Ms. Adelson could waive her Fifth Amendment privilege if she were to respond to an area, and
Well, presumably, it's your job to stop her from doing that, right?
Yes, Your Honor, but again, that's why, you know, the Fifth Amendment exists to protect the innocent from those types of
But
circumstances.
counsel, let's go back to the blanket assertion of immunity in this case. Ms. Adelson was identified as a state as being in possession of an iPad, credit card, bank records, lots of records that are subject to authentication at trial. Is it your suggestion that any attempt to discuss authentication would implicate her Fifth Amendment privilege?
Any testimony that could furnish a link in the chain to incriminating to incriminating Ms. Adelson would be subject to her Fifth Amendment privilege. The petitioner has not identified either at the trial court level or before this court, you know, what areas of proposed questioning that she believes would not implicate Ms. Adelson's constitutional rights. And our position is that any substantive questions posed at a defense deposition would be subject to Ms. Adelson's Fifth Amendment privilege. If, to the extent that Ms. Magbanua wants to ask questions that are unrelated to this case, well then those questions aren't relevant, and therefore the proposed deposition, as the trial court ordered, would serve no useful purpose.
Well, counsel, this may be a bad analogy, and you're probably too young to have known the game called Battleship, where two players play and they don't get to see each other's boards, and they put little battleships, and someone has to go A1, miss, B2, hit. Now, it's like a game of Battleship, I think, here, because the defense wants to ask certain questions, and some of those will be misses in the sense that they're not relevant, or I shouldn't say relevant, but they're not going to be protected by the Fifth Amendment. Other ones are the hits. Well, I'm not going to answer the Fifth Amendment. Why can't they engage in this battleship sort of deposition? Granted, it could be constrained in terms of time and scope in some ways, but why aren't they entitled to know what the battleships might be on the playing field?
Well, Your Honor, a criminal defendant has no constitutional right to a discovery deposition of prosecution witnesses. And even if a defendant did have a constitutional right, it would have to yield to Ms. Adelson's Fifth Amendment.
But we're not talking about constitutional right here. We're talking about there's a rule that allows the deposition, right? So the deposition is permitted. The question is whether your client's constitutional privilege overrides that right.
And it absolutely does. And the courts have held, again, that an individual's Fifth Amendment rights outweigh any right to confrontation. But even apart from that, Ms. Magbanua is going to have an opportunity at trial to question Ms. Adelson and to ask her whatever questions are relevant to her case.
That's not exactly true. She'll be limited by the scope of the direct examination, correct?
She will,
Because
correct.
you would object if she went beyond that, correct?
Yes, Your Honor.
Right.
But again, to any of these issues that Ms. Magbanua raises in this petition can be cured on post-judgment appeal. And that's what this court has held time and time again, and most recently in the Segura case, which was decided just 23 days ago, where the court...
It's not final yet either.
I'm sorry, Your Honor?
That case isn't final yet.
Yes, Your Honor, but the Utse case is final, and that was decided, I believe, in 2012. And I, contrary to what counsel for Ms. Magbanua said earlier, I think the Ute case is directly on point. In that case, there was an issue where the trial court precluded the defendant from introducing testimony at trial, and the argument was, there's no way that a post-judgment appeal would allow me to make a proffer as to, or to present, how that impacted the trial. And this court declined to accept that argument. It said, you can make the same arguments that you're making in this petition in a post-judgment appeal.
But isn't that case distinguishable on this ground? There, and you'd say there were items that were required to be produced in discovery that were excluded. And so those items were available for the trial court to assess and for this court to assess on appeal. Here, with regard to the questions that Ms. Magbanua may ask Ms. Adelson, not limited by cross-examination at trial, we'll never know what those questions might have been, what those answers may have been, nor when the Fifth Amendment privilege would have been asserted, correct?
Yes, but to
So isn't that an important distinction? That's a material injury that would never be correctable on appeal.
Well, Your Honor, actually, I believe the case of State v. Mesa is exactly on point for that situation. And in State v. Mesa, the Third District Court of Appeal addressed a case where two confidential informants refused to testify at a defense deposition and on the basis of their Fifth Amendment rights. And the trial court dismissed that case. The Third DCA reversed that and said, there's no sanctionable harm in that situation because at most the upshot of that is that two witnesses who may or may not have been favorable to the defendant were unavailable, at least pre-trial, to the defense. But that wasn't sanctionable harm in that case. And then this court in State v. Levette cited with approval to Mesa. Now, in regards to the material injury prong, which is part of the jurisdictional prong, Ms. Adelson has indicated that, as we've spoken about, she'll assert her constitutional rights to any substantive questions. And Ms. Magbanua, has not identified any relevant areas of inquiry, unrelated to this case that, she believes would not implicate Ms. Adelson's constitutional rights.
It seems like a little bit of a double standard, doesn't it? That your position is that she has no right to ask any questions, but now you're criticizing her for not specifying which questions she would ask. Why shouldn't she ask the questions and get an individual response and ruling on them?
Well, because the trial court determined that, based on his perception and knowledge of the case, which a trial court can use his knowledge and perception of the facts of the case, that Ms. Adelson does have a legal basis to assert her constitutional rights. And again, there's the risk of her appearing at a defense deposition and risking waiver or being subject to harassing questions. Counsel for Ms. Magbanua has made recent public statements concerning Ms. Adelson, who's a member of our bar, would potentially perjure herself. And this court, the trial court, based on its knowledge of the case, decided that a protective order was appropriate under these circumstances. And it's the trial court's absolute discretion to make that call, and it properly exercised that discretion. And even if this court were to accept certiorari jurisdiction, the order would have to depart from the essential requirements of law. And this court has held that means that it has to be a miscarriage of justice.
Well, it seems to me anytime a defense has a subpoena for a witness and the witness says, I'm going to exercise my Fifth Amendment rights and all substantive questions, game over. So why isn't that the game plan prospectively for every witness ever subpoenaed in the future in the state of Florida? I'm going to take the Fifth, game over.
Well, I would respectfully submit that isn't what happened here. The trial court actually did make a determination that Ms. Adelson had a legal basis to assert her Fifth Amendment privilege. This wasn't an instance where the trial court ignored that. And this court, unless that ruling departed from the essential requirements of law, then this court has to.
Give me the underpinnings of the trial judge's ruling. You said he ruled that there was a basis for it. What is that basis?
The basis was on not only the submissions, but the fact that this court has had this case for 2.5 years. The state in its brief represented that its theory of prosecution is that certain members of the Adelson family were upset about custody proceedings between Ms. Adelson and Mr. Markell, and that they contracted with Mr. Garcia and Mr. Rivera using Ms. Magbanua as a middleman to murder Mr. Markell. So Ms. Adelson, even though the state has never alleged her involvement in the murder, she's front and center on this issue.
Well, counsel, the standard under Rule 3.220 for issuing a protective order, which is the order on appeal here, is that there needs to be good cause. Ms. Adelson alleged that the deposition would necessarily inconvenience, embarrass, or harass her. And those are words that are used in the rule. Exactly how would the deposition do those things?
Well, first of all, having informed defense counsel that she would assert her Fifth Amendment right, she would have to sit for a defense deposition, which would and assert her constitutional rights over and over again. When a defense deposition is not admissible at trial, and there's no inference that the defense could get from Ms. Adelson's assertion. So that's the unnecessary inconvenience of having to sit for hours of questioning about her ex-husband's death when she's informed counsel that she'll be asserting her Fifth Amendment rights. With respect to the harassment prong, as we stated in our brief, statements have been made by other defendants in this case and also by Magbanua's counsel, Ms. Magbanua's counsel, trying to incriminate Ms. Adelson. And we cited to those in this brief, and the trial court is obviously well aware of those statements and statements that have come up, for example, at the Arthur hearing for Ms. Magbanua. So the trial court in its protective order has a right to preclude the defense from subjecting Ms. Adelson to harassment and asking questions or accusing her of perjuring herself at a defense deposition.
But that was not a basis stated in the protective order itself.
It was not.
And the protective order just doesn't say that there may be substantive questions or some questions. It just embraces a blanket assertion of Fifth Amendment rights.
It embraces an assertion to substantive questions, and I think what the trial court recognized was that any relevant questions that could be asked of Ms. Adelson would be subject to her Fifth Amendment rights, and any non-relevant questions would serve no useful purpose in this matter.
Counsel, I'll extend your time by an additional minute to wrap up.
Thank you. So Ms. Magbanua fails to meet the jurisdictional prong here of material injury that can't be cured on post-judgment appeal. For the reasons that this court has held time and time again, all of these arguments that she raises in this petition, she can raise on post-judgment appeal. Even if this court were to find that it had jurisdiction under the first two prongs, Ms. Magbanua cannot prove that the trial court's order granting the protective order departed from the essential requirements of the law. Counsel cited no criminal case requiring a question-by-question analysis of a witness's Fifth Amendment rights. So therefore, the trial court's order could not have departed from the essential requirements of law. So we would ask that the court either dismiss the petition for lack of jurisdiction or deny the petition. Thank you.
Thank you, counsel. We'll also extend the petitioner's time by 4 minutes.
Your Honors, there were certain points that were made by both the respondent and Ms. Adelson's attorney that I would just like to briefly address. The state's concern regarding the delay is no longer an issue. Ms. Magbanua moved to dismiss the emergency stay just for the fact that the trial currently is set for, well, the proceedings are set for June 18th for a status hearing to pick a future trial date, which is going to coincide with everybody's schedules as well as the court schedule. So the concern regarding the delay, I don't believe is a significant concern at this point. Of course, it will all depend on what the lower court decides in giving them a trial date. By allowing the state to ask questions on direct without deposition, the state is basically determining what evidence the defense is entitled to. The respondents admitted that the prosecution would be controlling the questions at trial, which is why they have not subpoenaed Ms. Adelson and which is why they refused to subpoena Ms. Adelson. It is giving the state an unfair advantage to control the evidence adduced at trial, which they just do not have the authority to do. In regards to Ms. Adelson's response, Ms. Magbanua is not asking for a bright line rule saying that this can just happen in all criminal cases. Certiorari should be analyzed on a case-by-case basis and based on the circumstances below. And it's Ms. Magbanua's position that the unique circumstances of this case warrant certiorari relief, and we're not asking for this court to set a precedent that is going to apply to all criminal defendants from here on out.
Well, it's going to be, I'm pardon my interruption, but it's going to be hard to draw that line in future cases, isn't it?
I believe that if this court were to stress the unique circumstances of this case, that we have a witness that is blanketly asserting her fifth. The trial court is being deprived of its role to determine whether the Fifth Amendment applies. And as I've said, I have come across no criminal case where this precise situation has happened, where a witness has asserted the fifth and has succeeded, but then yet still be allowed to testify at trial. And I honestly cannot foresee or hope that that would happen to a criminal defendant again in the future. So we're not asking for a bright line rule. We're just asking it to apply to the specific unique circumstances of this case.
You're not contesting that the trial judge, if this were to go back to the trial judge, could put pretty tight parameters on the deposition, meaning time, scope, and so forth. So at least some scope. You're not going to be asking stuff that's totally, clearly irrelevant. Or I would hope.
In regards, I believe I came across case law when I was researching the issue that the trial court actually can't pick the location and the time and the date of the deposition. I would have to submit authority.
I'm not so concerned about that. I'm talking about other parameters. We're currently concerned about delay. What I'm worried about is if, let's say, you do have a deposition. I mean, is that going to be a day, 2 days? Then you have to have the trial judge rule on all of it. It could take weeks of additional time.
Yes, Your Honor, it could potentially take. She is a very, very key witness for the state. She establishes the motive for the murder. I can't with any certainty state how long depositions may take, and how many questions she's going to assert her fifth to. And even if she does assert her fifth to certain questions, how it's going to have to go back before the trial judge, and there's going to have to be a hearing. The delay may be a concern. I'm just saying that in terms of when this petition was filed and the pending trial date, which would have been June 3rd, that is no longer, it's not as impending as it was before. But I really can't state with any certainty to this court how long a deposition would take and how long the proceedings would take to be able to certify those questions to the trial court in order for the trial court to rule.
At the time you have the battleship analogy, my concern is that if you get to play this game of battleship and you start asking lots of questions, that you effectively could implicitly determine what it is she's taking the fifth on, and thereby figure out where the battleship is. In other words, and she doesn't have to, she has a Fifth Amendment right. She doesn't have to tell you where the battleship is.
She absolutely has a Fifth Amendment right against self-incrimination. What she doesn't have is a Fifth Amendment right against the incrimination of others.
But you see my point is if you ask enough questions, you can kind of figure out, okay, this is where the battleship is.
Right. But if in the event that occurs and we ask enough questions, it still has to go back before the trial court to determine. And if the trial court makes a proper determination that it's protected by the Fifth and the defense is stuck with those questions cannot be asked during trial. We cannot put on a witness or cannot ask questions of a witness that we know she's going to invoke the Fifth in front of the jury. But it will at least give the defense ideas of areas for cross-examination, for further investigation that could help prepare her defense. As I said to that point, Ms. Adelson cannot make the determination that the deposition would serve no useful purposes. It's not her determination to make. And the trial court cannot make that determination without knowing what the questions are that's going to be asked. It's still our position that this, because of the unique circumstances of this case, that this cannot be remedied on appeal. There are several cases that are cited in the petition that speak about not being able to depose a material witness in a case and how there's no practical way to determine how that could affect the outcome of the proceedings. And this, Ms. Adelson's reliance on State versus Mesa is misplaced in Ms. Magbanua's opinion. In that case, the palpably erroneous decision that the Third District was talking about was a dismissal of the charges. The trial court had dismissed the charges because the person had pleaded the Fifth, and the Third District rightfully stated you can't punish the prosecution because a witness asserts his Fifth Amendment. That's just not what we have here. We're just being barred from taking her deposition. And she's, as I've repeated, she is more than willing, she's more than able to assert her Fifth Amendment privilege to questions that she truly believes are going to incriminate her. It's just that based on the evidence that's before this court right now, especially from the probable cause affidavit, the testimony that she has given so far to the police 5 years ago doesn't seem to incriminate her. It seems to incriminate her family members. And that's just not protected. As much as Ms. Adelson would like that to be protected, that's not protected by the Fifth Amendment.
Counsel, your time has expired. I'll give you a moment to wrap up.
Thank you, Your Honors. I would just ask that this honorable court issue a writ of certiorari quashing the trial court's order granting Ms. Adelson, granting a protective order for Ms. Adelson.
Thank you, counsel. Thank you all. This court will stand in recess.
All rise.